Okay, good morning. We can begin the second session of this seminar with Michael Moore. Today the topic is causation in Anglo-American tort law, and the time is yours.
Oh, thank you very much. Again, there is a written outline of roughly what I want to talk about. And again, I would hope we can do it in some segments so that I'll talk for a while, we can discuss, and then we can talk some more. As Jordy said, the topic is really the role and the nature of causation in the liability rules of Anglo-American tort law. Since Miguel has graced me with this European group of tort law, I think I could probably lecture on European tort law. It's not that different as far as I can see from the reading I just did last night in this book. If you have a copy of the book that I wrote, it's basically, I had told Jordy, chapters 4, 7, and 11, which runs through the nature of the requirements having to do with causation in tort law and some explication of their function or their rationale. So, yesterday was mostly, I heard particularly from the lawyers, mostly philosophical. Today will be mostly legal. That is, we'll really talk about legal doctrines in some detail, because I think the doctrines are complicated enough that, like our forebears of 3-4 generations ago, it's actually something of a challenge is to state what the law thinks causation is in some detail that makes it look like a coherent requirement. If you look at the amazing literature on causation in Anglo-American scholarship, between 1900 and 1935 or 40, the best and the brightest of those generations wrote these extraordinarily long articles, sometimes in 3, 4, 5, 6 parts, most of which was doctrinal exegesis, that is, going through the cases and trying to make sense of this as a coherent body of doctrine. So I don't find this an easy or particularly useless enterprise. I actually find it about as challenging as I think they did 60, 70, 80 years ago. So, yesterday I mentioned what's on Roman 1 of my outline, the role of causation prima facie in existing tort liability rules. I'll just mention it again because I think that's a simple descriptive question. I don't know how many of you, other than Miguel, are tort scholars, but isn't it embarrassing to have an area of law that you have to subdivide between strict liability, negligence, and intentional torts? We who specialize in criminal law feel sorry for tort scholars because their area is not as unified as ours. There is a battleground, at least in the American Academy, that is shown up by the fact that there are these isolated pockets of strict liability in an otherwise fault-oriented system of compensation, where negligence and intentional torts both depend on there being some fault. I do think what that reflects is the lack of dominance of a normative theory. One of the things I want to talk about are the different normative theories of tort law that compete for dominance in America, and the result is you have 3 sorts of what are called legal theories of tort law. There's nothing like this in criminal law, there's nothing like this in contracts. There aren't 3 legal theories of contracts or 3 legal theories of the criminal law. In the criminal law, we have the general part, a univocal, general set of principles applicable to all crimes whatsoever. Contract law has the same. So tort law is a little bit special. It's not as bad as property law, but it's still somewhat divided. So take it one at a time. Strict liability, as I said yesterday, the rules of strict liability are built on causation, particularly given the absence of any fault requirement. People like Richard Epstein in his famous article, A Theory of Strict Liability, Journal of Legal Studies, 1971, argues that causation by itself triggers a duty to correct what causation of harm does, which is violate someone's rights. Causation marks the border of the legal right you have to non-interference, and once someone causes you harm, now you have a duty of correction on that person's part and a right to recovery. Causation is the big dog for strict liability. It has a big role to play. With negligence, it is, as I said yesterday, in every American Hornbook on the law of torts, one of the 4 elements of the prima facie case for tort liability. We need duty, we need breach, which means negligence. We need causation, in fact and proximate, and we need damage, the four heads of a prima facie case in every American jurisdiction. So causation has a large role in negligence as well. It has the role I articulated for intentional torts. Sometimes battery is defined as causing contact. There the role of causation is explicit. Sometimes battery is defined not in terms of causation explicitly, but in terms of the causative verbs of English, like hit, which means a voluntary bodily movement causing contact. So the causation there is just as present, even if it's implicit rather than explicit in the words used in the liability rule. So causation has a large role to play in tort law. Indeed, it has a larger role than it does in criminal law. Because notice in criminal law, we have inchoate liability, that is liability without causation. We don't have that in tort law, with a few exceptions. Intending or risking harm without causing it gives rise to no liability. There's an old saying in American basketball, no harm, no foul. Same in American tort law. If someone's not injured, although there may be blame and thus punishment due, there's no corrective duty because there's nothing to correct. So causation, arguably, plays a much bigger role in tort law than it does in criminal law. There's also an interesting division of labor between tort and criminal law scholars in the Anglo-American world. There aren't many criminal law scholars who pay the kind of attention to causation to which I pay it. Most criminal law scholars defer to tort scholars and let tort scholars do the heavy lifting when it comes to theories about causation. And then criminal law and criminal law scholarship simply adopts tort law scholarship and tort law doctrines in its criminal law doctrines with minor modifications. If you look at the criminal cases in America, they often say, we use foreseeability for proximate causation just like they do in torts, but because the sanction is more severe, it has to be more foreseeable for there to be liability, for example. I think it's reasonably easy to see why torts is the home of the discussion of causation in the law and why criminal law picks up what tort scholars do. If you have as your essence of torts something like the negligence cause of action, namely don't unreasonably cause harm, there you are, that's most of tort law. Notice causation approaches a much more open-ended question than is approached if you, in criminal law, are using typical criminal code in Britain has 8,000 prohibitions, 8,000 things you can't do. In America, typical criminal code has 15,000. We're not as nice as the British. You got to have more things prohibited. But if you have specific prohibitions like don't kill, don't maim, don't hit, there are causal questions in all of those prohibitions, but they're much smaller, much less open-ended questions than simply saying don't unreasonably cause harm to somebody else, which is what negligence law says. The result is, given the open-endedness of negligence law, you end up with a lot more room to play in terms of the factual variations and the theories of causation you need to accommodate them. So not only do I think that there is this division of labor between torts and criminal law scholars on causation, I think it's also right. Tort scholars have harder causation questions to deal with than criminal law scholars, so we thank them for their efforts and we ride on their backs, so to speak. Okay, what I'd like to first discuss is the degree to which trying to make sense of the causal requirements of tort law in terms of normatively, why do the tort doctrines of strict liability, negligence, and intentional torts, why do all of them require as a necessary condition of liability that the defendant cause harm to the plaintiff? What's the normative point? To do that requires us to repair to what you think tort law is actually all about. What is tort law's normative point in general, and then we can isolate what causation's role would be according to those normative theories. I don't think that's the mess some people think that it is. I think there's only three families of theories about torts that I go through on this outline. Before I get into the details, there's three theories of torts because there's three theories of contracts, there's three theories of property, there's three theories of criminal law, three sorts of theories. It comes from, I think, the way that social and political theory is naturally divided. There are first and foremost utilitarian theories. Utilitarianism is simply a social theory with two sorts of premises. One, it has a theory of what's intrinsically good. What's intrinsically good is welfare in some sense. either Bentham's hedonic calculus, pleasure, John Stuart Mill's subtler and more elusive happiness, the preference satisfaction of the ordinal utilitarians, the economists, following the ordinal revolution of 1900. Whatever you mean by welfare, a utilitarian is committed to there being one intrinsically good thing. There are lots of other good things, but they're only good insofar as they contribute causally to the production of welfare. And then the second part of utilitarianism is a theory of right institutions and right actions. A legal institution is right, that is just, in the utilitarian sense, if and only if it maximizes the net sum of welfare. So if you're an economist and you're doing preference satisfaction, that means the net sum of satisfied preferences is what the right legal institution would do. And from Bentham to Posner, the argument is the same for all utilitarians. What makes an institution justified, such as tort law, is that it has a structure maximizing the satisfaction, if you're a preference utilitarian, the net satisfaction, the net sum of satisfied preferences. So that's utilitarianism generically. Utilitarian theory of torts is then one that says you use tort liability rules like monkeys. You put the monkey on the back of the person whose behavior you want to incentivize, to give deterrence to, if you like. Liability is an incentivizing device because people don't like to pay money any more than they like to go to jail. In which event, by placing liability on a person, you can get them to do something. The something you want them to do if you're a utilitarian is optimize. That is, to make us all better off in whatever activity that you're doing. So tort liability is just a form of utilitarianism. You can make the same arguments about the shape as Bentham to Posner do, the shape of property, the shape of criminal law, the shape of contracts. The utilitarian theory is general enough to be a theory of all of those areas. As opposed to what? As opposed to justice theories. Justice theories that say simply making people as happy as they can be is not the only intrinsically good thing. Kant is usually paraded out as an anti-utilitarian, and he certainly was. He says in his later works in the Rechtslehre, beware the serpent windings of utilitarianism. There are other good things, such as justice, not reducible to utility, that should be served. In tort law, the kind of justice ever since Aristotle people have thought tort law can distinctively serve is not the retributive justice that gives rise to criminal law, but rather the corrective justice, in Aristotle's terms, that gives rise to compensation. So if I go into your house and smash your rare Ming vase, intentionally, negligently, or on some versions just inadvertently, Aristotle would say, I have a duty to correct the injustice I myself have brought about. It's a secondary duty. My primary duty was not to break your vase. My secondary duty is to pay you if I do. In which event, if there's a secondary moral duty to pay, tort law can be seen as simply making you do what morality already tells you have a duty to do, which is to pay for the harms you yourself have culpably brought about. So a corrective justice view says tort liability doesn't exist to incentivize efficient behavior. Tort liability exists to force you to do what morality tells you ought to do, namely correct the injustice you have caused. And that is corrective justice then being served by tort liability rules. There is this third family of views that I think speaks from distributive justice. It says law sometimes should not be seeking to make us all better off. That's what the utilitarians do. It needn't also be seeking to enforce pre-existing moral duties like the duty to correct the injustices you've brought about. It can simply be that we should distribute the downside risks of living together in society in a fair way. We distribute the upside benefits of living in society in a fair way. Progressive income tax redistributes some good stuff, income. Tort law, on this view, exists to fairly distribute the downside risks, the risks of getting hurt, getting disease, of natural catastrophe, and the like, in a fair way, which typically means in an equal way. Distributive justice theories tend to be, like Rawls to Amartya Sen's, to be egalitarian. The desert base is not what you've done. The desert base is simply a person in need. So I see that Obama this morning has allocated $100 billion to Haiti. It's not that anybody's responsible for the storm. We're not correcting the injustice. It's not like the butterflies of Florida caused the storm to go over to Haiti. We have nothing to do with the etiology of the storm. But nonetheless, as a matter of international distributive justice, we're wealthy, they're poor, they got hit with something that wasn't their fault either, and like the ancient Incas, we will distribute the loss that comes from the whims of nature so that we all share it a little bit rather than them sharing it entirely. That's a distributive justice view. And in tort law, those are usually called compensation systems. In America, there are two historical examples of compensation systems: workman's compensation, which came in around 1900 to 1920, and then the no-fault auto plans of the 50s, 60s, and 70s in America. But New Zealand has shown us all, shown the world what you could really do if this is what you want to do, which is you have a general social insurance scheme that shares all catastrophes shared by New Zealanders. So if you're diseased, or you're hit with a car driven by somebody else, or you're hit by a boulder, a natural catastrophe, or anything else that's not your fault, then you share that with others. Some people think of that as not tort law. That's sort of anti-tort, a replacement for tort law, and that's a perfectly good way to think of it. So three sorts of normative theories of tort. My question really isn't sort of what the theory of tort law is, although I think that's an interesting question. Happy to talk about it. But the role of causation in each of these views of what tort law is all about. So take utilitarianism first. That actually is an amazingly complicated question. When I left law practice, one of my partners looked at me and he said, I practiced for about 5 years, they were going to make me a partner. I said, I got to get out of here, I can't make this much money, I can never become a teacher again. So I left. He took my files and he looked at them and he said, did you get all the complicated cases in the office, or did you just make them complicated? I.e., did you sort of divide them up in a way that now makes them much harder than they had to be? I do think American scholars have made this harder than they had to. But let me just give you a thumbnail 200-year history of utilitarian theory of torts and the various ways in which causation does and does not enter into these theories. It's kind of a fascinating tale, at least I think it is. I have 4 stages. Actually, I think there are really 5. Start with 1789, Bentham's Principles of Morals in Legislation. Bentham, in his Political Economy, followed by Mill in his book on political economy, say the following about tort law. Tort law should be used to incentivize optimal behavior. So, take the classic case of nuisance. You've got an apple orchard here and a set of cedar trees over here, each owned by different people. They're within 2 miles of each other, and it turns out, as a matter of entomology, tree science, it turns out cedar trees generate a cedar rust that, if they're within 2 miles of an apple orchard, spoils the apples. Put simply, you cannot have both cedar trees and apples within 2 miles of each other because the apples will be destroyed by the cedar trees. So you've got an interfering use, which the tort of nuisance is designed to deal with. Bentham's solution. Figure out as a regulator. Bentham's not a free market economist, he's a regulator economist. Figure out which is the higher valued activity. Which is the thing Virginians need the most to be happy? Which is the one that makes Virginians, if this is the state of Virginia, which it was in the famous case, which is it that makes the Virginians happiest? The Virginia legislature did exactly that in the 19-teens. They said, well, Virginia apples actually is a real industry. It produces wealth and it actually produces jobs. Cedar trees aren't good for much. They're not good. The lumber in them is too weak to build anything with. They're very pretty. They're basically ornamental. Between the two of them, we think apples are worth more than cedar trees. In which event, since you can't have both, we will use the tort liability rule of nuisance to put the liability on the back of the cedar trees, because that will discourage cedar and encourage apples, and apples are what makes us happy. Straightforward government regulation. You look at 2 activities, decide which is the more valued, and on utilitarian grounds, discourage the least valued with a tort liability rule. The other way to think of it, of course, is you encourage the more valued activity with a property entitlement rule. They're mirror images of each other, although the shape of the rules, the shape of the sanctions actually is different. But that's Bentham's approach. In 1912, there was a book written by Pigou called The Economics of Welfare, an economist following the Ordinal Revolution that transformed utilitarianism from Bentham's cardinal utility to the ordinal measures where you can't do intensities, you simply do comparative utilitarianism. On Pigou's view, you had to actually make apples liable not for Bentham's, you have to make cedar liable not on Bentham's ground that apples are more valuable than cedars, but it's rather a pure causal question. Pigouvian welfare economics, 1912 to 1960, the dominant educated view of utilitarian torts in America, said you had to make tort liability follow causation exactly without regard to fault, because one of the costs of having ornamental cedar trees is that they destroy apples. And to price cedar trees in a market so that the preferences of persons bidding with dollars can accurately reflect how much they want cedars versus apples, you have to include in the price of cedars the cost of the destruction of the apples. As he said, it is a true social cost of cedar production that apples are destroyed by having cedars if they're within 2 miles of cedar trees. In which event you use the tort liability rule to place liability on the causer of harm without regard to fault for a good utilitarian reason, Pigou said. It's to get the pricing mechanisms to reflect true costs of production, and that way you won't overproduce cedars and underproduce apples. Then Virginians can decide, when the goods are correctly priced, how much they want of each, and that will maximize the net sum of satisfied preferences of Virginia consumers. For a long time, 1912, 1960, that was a dominant view called enterprise liability in American tort law, particularly in the 1950s. Notice it makes causation absolutely central. Whereas for Bentham, causation had nothing to do with where you placed liability. You had to decide which activity was more valuable, and you placed liability on that activity, whether it was the causer of harm or whether it was the one to whom harm was caused. Causation didn't matter to Bentham. It made all the difference in Pigouvian welfare economics. Third phase, 1960, the Nobel Prize winning work of Ronald Coase, often called a causal skeptic. He was a causal skeptic because he said, it doesn't matter who causes the harm for utilitarian purposes in tort law. What matters is that each enterprise, cedars and apples, internalize the costs, the true costs, of having cedars and apples. But, and this is the crucial insight usually called the Coase Theorem, but you don't have to make cedars pay for harm caused to apples to get cedars to include in the price of cedars the cost of the apple destruction. Why not? Because in a costless market, the possibility of apples buying off cedars so that they'll cut down the trees and not destroy apples was always there. You can put the Coase Theorem very simply. Opportunity costs are real costs. The opportunity for cedar to extract a payment from apple was always there, always included in cedar not doing that, and therefore cedar valued cedar more than apple wherever there were cedar trees next to apple trees. Given that the transaction costs are low relative to the difference in the utility of the two activities, Coase, 1960, Nobel Prize winning work, you will have cedar trees or apple trees, and it will be efficient no matter what tort law does. That makes causation totally irrelevant to tort law if you're a utilitarian, and now you can do something else with your liability rules because it doesn't matter. Coase said, I know that in the real world sometimes the transaction costs exceed the difference in utility. Well, if that's true, he said, then you have to go back to Bentham. Then you have to figure out what the highest valued activity is, in which event you place tort liability away from the highest value-add activity because you're trying to guess what a costless market would do. But as Coase said, going back to Bentham still means Pigou is wrong. Namely, 1912, 1960, the whole thing's just a bloody mistake, which is why he got the Nobel Prize. It is a mistake. Bentham's utilitarianism makes sense, has nothing to do with causation. In a costless market, Coase makes perfectly good sense, has nothing to do with causation. The only guy who thought as a utilitarian causation was relevant to tort law, Pigou, is just wrong. Has nothing to do with tort law on a utilitarian basis. The fourth phase is really this very famous book. It's quite a good book. I reread it recently. Just once in a while, it's good to reread the classics. It's It's as good a book as I thought it was in 1970. Guido Calabresi's The Costs of Accidents. Guido's is often called a quasi-market solution because it builds on Coase's attack on Pigou. He's a utilitarian, an economist, and wants to say, let's make tort law make us maximize something we want, or put up in other words, minimize two things we don't want. Nobody likes to suffer accident costs, and nobody has fun spending safety costs that prevent accidents. What we want for efficiency is to minimize the net sum of accident and safety costs. That will make society happiest. Minimize the net sum of accident and safety costs. How do we do that? Well, you could do with Bentham, he says, the rough guess as to which is the higher valued activity. But remember when this is written, 1970, economics is much free market. He says, but if we could use the market to determine which is the higher valued activity, we wouldn't have to have these nasty government regulators making the decision whether apples are worth more than cedars. Since the transaction costs for tort liability often exceed the difference in utility, you can't rely on the Coase Theorem to generate efficient results no matter where you place the liability rules. Calabresi's essential insight. It may be in certain transactions, some people are better able to act in the market to correct any misallocation of an entitlement or a tort liability rule that has taken place. And what you should do is put the monkey of tort liability on the back of the most efficient marketeer. So, some people have more information about their own preference schedules, about the production costs and the like, than somebody else. Apple producers, for example, may be commercial and have some advantage in that direction over cedar growers who are typically just residences. Secondly, there may be less of a free rider problem for one side of a transaction than another. Cedar growers, being non-commercial, may have a number of them, and a number of people will have well-known collective action problems in expressing their preferences through a market. But a unified apple producer will not. A unified apple producer will be somebody who doesn't have free rider problems, who's economically rational, knowledgeable, and also, incidentally, has lower transaction costs in the narrow sense, namely he's already got lawyers on staff than these residences. If there's someone who has market advantages, Calabresi, then what he calls the primary accident costs, safety costs, can be minimized by putting tort liability on the back of the best marketeer. How come? Because he'll act in the market to get rid of it. It's a complicated theory. It's an elegant theory. What's the role of causation in it? At one level, no role whatsoever. Calabresi says, take auto accidents. It might be most efficient, that is, maximizing of utility, if what you did was make all television manufacturers liable for all car accidents. That's his example. And that makes you think, why the hell would you make television manufacturers liable for car accidents? He says, suppose it were true. People who make televisions have all this information about apples and cedars and so forth. So they got information. They got great lawyers, so they got low transaction costs. There's only a few of them. They're oligopolistic, so they don't have free rider problems to act in the market. It might therefore be the best thing you could do to make television manufacturers liable simply based on their television manufacturers for all auto accidents, because they can then act in the market to find the cheapest cost avoider of avoiding the accidents. Why would they do that? Because they're liable for them. If they're liable for them, they're going to try to minimize them. And they will minimize them in an efficient way. That is, they'll spend that last dollar of safety cost that will get rid of more than a dollar of accident cost discounted by its improbability. The example is designed to show you that causation has absolutely nothing to do with where you would put tort liability rules as a first cut. But then Calabresi says, but of course we know it's implausible that television manufacturers would actually be that efficient acting in the marketplace. Probably someone who causes the harm is at least among the people who could most efficiently avoid the harm, if it's efficient to avoid the harm, because there's a cheaper safety cost than there is an accident cost. So probably people who cause the harm are among the cheapest cost avoiders, but that's only a rule of thumb. Television manufacturers are better at calculating how they should bid in the market to prevent auto accidents. All the liability should be on them. So notice the role of causation on this view of utilitarianism is not empty, but it's only a proxy, a rule of thumb, a heuristic, a probability that amongst those who might be the most efficient place to put tort liability, the causer of the harm could be amongst them. Calabrese thinks that's likely enough that in many contexts he then came to advocate strict liability for certain sorts of producers of harm like auto manufacturers as a matter of utilitarianism. The last theory I want to mention that's not on the outline is Dick Posner's, the Chicago law professor turned Seventh Circuit federal judge. The famous debate between Posner and Calabrese was a debate in utilitarianism about whether you should have strict liability, but it really was the debate between the free market economics of Coase and Calabrese against the regulatory approach of Bentham. So take the very first article that made Posner famous, A Theory of Negligence, 1973, Journal of Legal Studies. In A Theory of Negligence, Posner explicitly says courts should be regulators like Bentham said they should be. They should use the negligence standard to make people who could prevent more than $1 of accident costs be prevented by less than $1 spent in safety costs, and that's precisely what the negligence rules, including the definition of negligence itself, achieves. That means on a case-by-case basis, activity by activity, courts regulate and place liability on individuals when, but only when, they had cost-effective means to prevent an accident that occurred. That's what he said negligence should be about. Well, that's just the regulatory approach. Pick the activity that actually could prevent more harm than it costs to prevent it, put the liability on that activity to get it to do it, and otherwise leave them alone. That's basically Bentham. So we've come full circle. Now, why that complicated story strikes me as unduly complicated is because if you think for just a minute, isn't it obvious that from Bentham to Posner, that's about what utilitarians should think? Utilitarians want tort liability rules to give incentives to optimizing behavior by citizens. Where do citizens calculate the relative costs and benefits of any given action they're contemplating? Well, they can't calculate it vis-a-vis causation. Causation hasn't happened yet. They calculate in terms of probabilities and risks. Ex ante calculation is the point at which the deterrent bite of tort sanctions can happen. In which event, if I were a utilitarian and an economist, I would say exactly what Bentham to Posner says. Place tort liability not based on who causes the harm, place tort liability on the person who makes the wrong calculation of risk. Prima facie, it's probability and risk that should be the trigger of tort liability. If you use causation, it's only as a proxy for something you're finding hard to measure, which is probability and risk. But you'll probably end up doing what Posner explicitly does, so does Landis, so does Calabrese, so does that youngster at Harvard who's not so young anymore, another economist. All of them define causation in probabilistic terms, because as economists, they should. If you're trying to use tort liability rules to give incentives to efficient behavior, the bite of a rule should occur when the person's doing the calculating, and in terms of what they're calculating. What are they calculating? They're calculating risks. They're not calculating actual causation. They're calculating the risk, in which event probability should be where the liability attaches. So, long story for a short answer. For utilitarians, causation doesn't have much role to play, shouldn't have much role to play, except indirectly as a way to measure risk as a heuristic. Well, that took a while. Let me see if I can be a lot quicker with corrective justice. Corrective justice theories. People tend to associate with the fault principle, and that is the dominant view of corrective justice, from Aristotle to Oliver Wendell Holmes. Corrective view of the traditional view of corrective justice goes like this. Losses in Western societies lie where they fall. That is, everybody has to carry their own water. We don't distribute them like the Incas or the communists. Losses lie where they fall, save and except when a culpable causer of the harm causes harm to an innocent sufferer of that harm. So if you have both fault and causation, then you have liability, otherwise losses lie where they fall. That, I think, is the traditional version of corrective justice people call the fault principle. I actually think it's also the most defensible version of fault, but just so you don't get parochial, Look at some of the other versions that have been proposed of what corrective justice is about making sense of tort law. One is Richard Epstein's famous version. If you cause, you pay. If you violated, as he calls it, a boundary crossing, you violated a right simply by causing harm, even if you weren't culpable, you should pay prima facie for the privilege. To cause is to become responsible for something. Now, there's a little plausibility to that. Think of, I gave my tort students last year the following. It was a true case. My case. My tree fell on my neighbor's greenhouse. She had this ancient greenhouse. It was a gorgeous thing. My tree smashed it to bits. So we're not talking small numbers of dollars. I looked up I didn't look up utilitarianism. I think I know that one. I looked up Illinois tort law on nuisance for adjoining landowners, and I found what I thought I would find there. Nuisance law is governed by the negligence standard defined in learned hand terms. Namely, only if I had sufficient notice of the tree's rottenness that I was culpable in not preemptively cutting it down, would I be liable for the damage to my neighbor. Now, I live in a very small town in Illinois of 5,000 people. My guess of the sociology of that town, I think, is correct. That isn't what good neighbors do. You don't let losses lie where they fall. My tree is lying on her greenhouse. She will make me the pariah of the neighborhood if I don't pay for it. But that isn't what tort law says. Tort law says only if you culpably cause the harm. That means at least negligently, which it means at least in this instance I had enough notice that a reasonable landowner would have taken precautions. This was a big storm. I actually did have some notice, but she didn't know I had any notice. Should I pay for it? I think half of my torts class thought the answer was I should pay for it. Well, that's Epstein's kind of theory of corrective justice. If you cause the harm, even if you don't culpably cause the harm, you ought to pay for it. You're the one who's disturbed the status quo. You therefore have the corrective justice duty to put it back. It's as simple as that on Epstein's view. Notice causation does all of the work on such a view of corrective justice. Therefore, Epstein thinks strict liability actually should be the rule rather than the exception throughout torts. Secondly, there are risk-based versions of corrective justice. The famous risk cases like Herskovits in the American law of torts, where you can't prove 51% likely, you can't prove more probable than not that someone has caused a loss. What you can prove is that they caused a loss of a chance, the lost chance cases. So you might say, well, risking, it's not the causing of harm that's wrong, simply risking somebody else is wrong, and actually risking them actually hurts them. It's not the causing that hurts them, the risking of the causing hurts them. So plaintiff suffers a harm when there's a risk, and defendant does a wrong when he risks, in which event you have a corrective justice duty built on risks. It's a very famous article by George Fletcher, now at Columbia, my former colleague at UCLA, called Fairness and Utility in Tort Law, Harvard Law Review 1972, where Fletcher modifies that just a little bit. He says what really determines tort liability, or should determine it, is asymmetrical risk imposition. Since we all risk each other all the time, right? I don't know, some of you may have some bad ears, in which event my shouting at you on occasion could, I'm risking breaking your eardrums. It's not very likely. But we all risk each other all the time, Fletcher's point. It's only when in a two-party relation, I risk you more than you risk me, that I should compensate you for the excess of risk that I'm imposed. Famous example, the dangerous animals cases. In certain areas of cities in which I've lived, you can keep ocelots as pets. Ocelots are wild cats. Suppose I have an ocelot and you have a German Shepherd. German Shepherds are pretty good dogs, but let me tell you, my ocelot will take your Shepherd 10 times out of 10 if they get together. I keep my ocelot non-negligently, that is, I'm a safe, reasonable ocelot keeper. You do the same for your Shepherd. But you know, animals get out anyway. We're both reasonable, they get out, my ocelot kills your Shepherd. Do I have a duty to compensate? Fletcher, you do, because my ocelot is risking your Shepherd in a way your Shepherd is not risking my ocelot. I get the benefit of having an ocelot by imposing on you an excess of risk. You get the benefit of having a Shepherd, but you don't have to impose a risk on me. I should pay for the privilege of imposing an asymmetrical risk on you, Fletcher's theory of torts. That is a corrective justice theory. I have to correct the injustice I have brought about by having an activity that not unreasonably, but nonetheless imposes an excess risk upon you. Now notice on that theory of torts, there's no essential rule for causation to play. It is interesting that Fletcher realizes we don't have risk meters. We can't measure risk easily. So he uses causation the way Calabrese as a utilitarian uses it as a proxy for risk. For repetitive transactions, if my ocelot eats your shepherd, that is, he causes you the loss, and I have to pay for it, that will be a rough proxy both for the risking I have done over time of your shepherd over my ocelot, and the harm the shepherd owner has suffered by being risked. The harm caused is a good proxy for risk suffered. The harm causing is a good proxy for risks imposed. Fletcher uses causation, therefore, as a proxy for what really determines your corrective justice duties, which is undue risk imposition. That's the theory of corrective justice of Fletcher's version. There is, thirdly, even a different family of theories, what I call unjust enrichment theories of corrective justice. You can see that in cases, the famous case of Vincent v. Lake Erie from the Minnesota Supreme Court early in the last century. In Vincent v. Lake Erie, the ship owner came into a harbor on the Great Lakes in Minnesota, tied up to a dock because a storm was approaching, and the ship with its passengers and cargo would probably have sunk had it to go out into the storm. The storm, of course, brought waves into the harbor, and the ship owner kept relashing the ship to the dock, and of course the big ship banging against the dock, damaged the dock, destroyed the dock at about $519.14. Destroyed the dock. The ship owner, when sued by the dock owner for the damage to the dock, said the following: I didn't do anything unreasonable. My ship was worth more than the dock. If I put to sea, I risked losing the ship, losing the cargo, and even killing the passengers and crew. A $500 dock being destroyed is a lesser harm than a ship, in which event, on a learned hand calculus of risk, the benefit, the burden of the precaution, loss of the ship, simply was greater than the loss being risked, loss of the dock, in which event I wasn't negligent. Minnesota court said the following: you're liable anyway. You did the right thing. Congratulations. You did the right thing in tying up to the dock. Now pay for it. Because you got all the benefit of saving your ship. The dock owner got all the downside detriment of you saving your ship. You're unjustly enriched by consuming his dock to save your ship. You made the right choice, ship over dock every time, but you ought to pay for the privilege. As a matter of corrective justice of the unjust enrichment version, you have had a benefit at the expense of somebody else, now pay for it. Notice there's nothing essential about causation in that. How you got the benefit doesn't matter. If your horse floats downstream in a flood onto my land, I have to disgorge the benefit, even though I didn't have any causal role in the production of that benefit coming my way. In Vincent v. Lake Erie, of course, lashing the boat to the dock did cause the damage to the dock along with the storm, but that's incidental. The benefit has to be disgorged because the benefit belongs to you, not to me. That is the essential unjust enrichment theory, which has an incidental role for causation. Try this version. As I have on the outline, how about in Vincent v. Lake Erie, it's an intentional use of the dock by the ship. What if it's not intentional, but it's inadvertent? So, my wife and I have both taught torts for almost 40 years. We're driving down the road together in the middle of America on a freeway. Construction has narrowed the freeway so they've blocked off 2 lanes, and so we simply have 1 lane for each way of traffic. In those days, we were teaching at the University of Pennsylvania. We had a very large trailer, mostly full of her clothes, a very large trailer behind us that I was towing with a pretty good-sized truck. I was coming onto the highway when a white station wagon filled with a standard issue American family, father driving, mother, 2 nice kids in the back seat, pulled out into this construction zone and stopped, realizing that he shouldn't be out there because he's on the freeway. There was no on-ramp because of the construction. I had an immediate choice. If I hit him right on the driver's side, I would probably kill him and most of his family. So instinctively, I swerved to the middle knowing what was true, which was a giant American 18-wheeler truck was coming the other way. I swerved to the middle. I took out 4 of the orange barrels in the middle, which then went careening onto the truck. Happened to have just enough room to get by the truck and back into my own lane without hitting the New Yorker or hitting the truck, but the barrels crashed into his truck and ruined the front of his truck. So we all stopped. And he said to me, "You owe me for my truck." And I said to him, "Wasn't my fault." Vincent v. Lake Erie sort of argument, right? "Wasn't my fault. What'd you want me to do, kill the New Yorkers in their white station wagon? I chose the lesser evil, so I can't be liable to you for doing the right thing." Now, of course, he's a trucker. He hasn't been reading American tort law. He didn't say Vincent v. Lake Erie, right? But my wife teaches tort. She said you should pay the guy Vincent v. Lake Erie. And I said, but I didn't intentionally damage his truck. I risked his truck, but I didn't unreasonably risk his truck. I'm not negligent. And the law of torts in every American jurisdiction, Wyoming included, although it would make me liable for the intentional damaging of his truck, it does not make me liable for the reasonable risking of his truck, and I won't pay him. So we argued as we go down the road, and I said, all right, we'll settle this. We'll stop at our insurance agent in Laramie, Wyoming, and we'll ask him. So we stopped at State Farm, and the guy says, of course you're not liable. Wyoming tort law doesn't make you liable. Even though, notice, the benefit to me of not having the accident, the benefits to me, the downside risk is all to the trucker. He feels I've been unjustly enriched. But at least in terms of standard American tort law, I have no corrective justice duty because I only risked it, I didn't intentionally consume it. Now, on my wife's view of corrective justice, I had a duty to correct even in that case as well, and in that such a case, it's also incidental what role causation plays. So that's a long and complicated story of the different normative theories of torts. I'm curious what you think of both the normative stories and of the role of causation. Causation plays a role at the end of this story, really only in, I guess I didn't talk about distributive justice theories, but you ought to see off the top, causation has nothing to do with the New Zealand plan. It doesn't matter how it was caused. If you're a person in need, you get some money. So causation's out of the picture on that view of tort law. I'm curious what you think about the role of causation. The only place causation plays the kind of role it actually plays in legal liability doctrines is in the traditional or the Epsteinian view of corrective justice. There, causation plays the role it should play according to those versions of corrective justice. So, why don't we stop there for a bit and we'll talk. Yeah.
I think that there can be one interpretation of what you just said about the compensation system. Maybe causation is relevant in some compensation systems. In which way? In the way that society might feel that certain particular kinds of damages, harms, are the consequence of the normal functioning of their way of life or their institutions. For example, in a society where the transportation is an essential part of our way of life, it makes sense to share the costs of the losses due
to share amongst those transporting, or to share in everybody in society?
Our activity that causes all the losses.
Okay, now how does this get to compensation systems? When you say our, do you mean everybody? Let's take Spain. Everybody in Spain, or just the people who do some transporting of goods, or all the people who buy those goods? Who's the we?
The we, even I who I do not drive or take the bus, for example. I brought and I get to my work, to my job just because I take the bus. I couldn't do it without the bus. So I have to contribute when I buy the ticket. Some part of the ticket is the insurance that will pay for my own injury, or my own harm if I get injured.
But that's not a compensation system as such. It's a distribution of the risk to all those who benefit from the activity, right? I didn't do that. There is a theory in the 19th century. It was Baron Bramwell in the 19th century who had that view, the activity that everybody shares should bear its cost, not because it's efficient. It's not a utilitarian. It's a matter of fairness, not utility. As a matter of fairness, everybody who uses the transportation system should kick in for the costs it imposes. But that means if I walk all the time, I shouldn't pay anything, right? So it doesn't come out of the general tax base. It's got to come out, as you say, of the ticket prices.
We can think of other examples. I'm not saying that the New Zealand compensation system is based on their ideas. I say that it's possible to interpret some compensation systems based on that idea.
See, I think
another example, for example, the losses that we suffer as when a bank goes in bankruptcy.
Yeah.
Sometimes the state has a way of compensating all the victims. And why? Because it's what happens when certain institutions work just as they should work. Sometimes people get lost money and, okay, we should compensate them. It's a normal result of certain financial systems, the way certain financial systems work.
Yeah, I don't think you've said anything that I wouldn't agree with there. I think if you've got insurance with regard to deposits like we do in America, you kind of think it's perfectly fine if we want to distribute the risk of bank failures, which turns out to be a big thing these days. You could do it to the general tax base. If there were a group of taxpayers who didn't use banks, I don't know who they would be, but suppose there were some mattress people who put all their money in mattresses. They don't use banks. Not clear to me the general tax base should be, as a matter of fairness, the source. It ought to be the people who use banks.
First of all, I wanted to say that I don't think that no-fault systems have anything to do with tort law. You know, I am allowed to believe that this is an alternative,
Sure.
and I understand that it's an alternative system. And when you talk about causation, you know, I mean, I think that causation plays a role in all cases, but the role is a different one. You know, so for instance, when you talk in your book about causation and responsibility.
Mm-hmm.
So the idea I have is that you're talking about causation from a legal point of view and responsibility from a moral point of view.
Yep.
You know, in that sense, I understand that causation does not play any role in some areas, you know, but from the technical point of view, from the legal point of view, so to say, of course it plays. You know, I assume that when you mean that causation and responsibility, you say, well, why should I be responsible from a moral point of view? You say, well, because you have caused the harm. You are blamed for it. Now, in other cases where you are not, then of course you are not. Mm-hmm. And the main problem that we find sometimes with Anglo-American tort law is that Anglo-American tort law uses tort law in many areas where we don't use tort law in Europe. You know, so it's a maiden of many works. You know, it's like a Swiss knife tort law in America. You know? and in Spain or in Germany or in continental Europe,
yeah.
We solve the problems with different tools. You know? So we have the tool of social law, we have the tool sometimes of criminal law, much stronger than in some areas. You know, so this combination makes that, for instance, well, all this economic analysis of law is wonderful if tort law is the only tool you've got. You know, but sometimes criminal law is much more powerful. You know? So I am an old-fashioned man who sticks to the corrective justice side, so to say, you know, and I think that in this area, causation, as in the other areas, plays a role, and of course in the case of negligence, of liability based on negligence, causation is from the moral point of view, it probably plays the key role.
Yeah.
But don't you agree with that?
I do agree with everything you said. Absolutely. Notice I did two things. One, I simply gave a description of American tort liability rules, and that's easy. Causation plays a big role in American tort law, just like it does in Europe. The normative stuff is harder, the law you ought to have on different normative ideals, but like you, I'm a traditionalist. I think corrective justice is the thing tort law can best do. The other things, like incentivizing efficient behavior or distributing downside risks so that nobody gets thrust out of the game, other areas of law can do better. So I'm with you. Corrective justice, indeed, I'm with Aristotle. Traditional corrective justice based on causal fault is what I think tort law should be about. So, yeah, I agree with that. I also think it's the case. It is probably the right labeling to think that New Zealand has thrown away tort law rather than having a theory of tort law. And I think Holmes thought that in the common law when he said a social insurance scheme isn't tort law, it's something else, and it is. But notice that's true about distributive justice in other areas of law, too. People who have distributive justice views of the criminal law are the people who have what are called rehabilitationist views, that criminals come from the disadvantaged classes, crime is a disease, you have to expend special social resources to correct this disease on their behalf. Most people say, well, that's not criminal law, that's not punishment, that's a different sort of theory. That's something else. And the same in property. Distributive justice leads to the famous aphorism, property is theft. It doesn't lead to a theory of property. So it's the same, I think, for torts. So, yeah, I agree with everything you said.
And the examples you made examples about, I think you were talking about the tree falling over a greenhouse and destroying the greenhouse, you know. So we have two solutions in Spanish law for that, you know. One is the preventive solution, so there is a provision in the Spanish Civil Code that says that you have the duty to cut down the trees or the parts of the trees that may cause a problem to your neighbor, you know. And if you don't do it, and public authority tells you to do that, you know, a public authority can order to do it on your expenses, you know. But this is a preventive part. But if you haven't done that, no one has done that, and the tree falls, you know, then you are liable because you did not do that. So there are two moments of saying that.
Sure. Well, the way I solved that particular problem I thought was clever. I documented that my wife was negligent in not knowing that the tree was rotten, and that got the liability carrier to have to actually pay for the greenhouse. So I didn't pay, and I didn't frustrate my neighbor, but my wife thought it was a little unfortunate I had to characterize her as negligent to get my liability insurance carrier to pay for it. What did you think of the Wamsutter example? Do you think I should pay for the truck? I wasn't at fault. I was reasonable. But I saved myself, and the trucker, who had nothing to do with anything, suffered the downside detriment.
You should pay for that, right?
I didn't. Well, as a matter of law, I clearly shouldn't pay for it. As a matter of the law we ought to have as an ideal of corrective justice, I find it a close case. I ultimately decided I shouldn't pay.
According to European law, that would be defense, right? So defense probably in this case of a state of necessity. At least I don't know about criminal law, it's from the civil law point of view, you know. But this defense does not excuse you for paying the harm you have caused.
But that's for intentional torts that necessity is a defense. For negligence, it's built into the concept of negligence that I actually wasn't behaving unreasonably. I did what I should do. I should risk the trucker rather than risk the family of four. So I did the right thing. In America, that wouldn't make even a prima facie case of a tort. And I think that's correct. Well, let me go on to causation itself, because we spent a long time on the normative theories.
If I may, I have a question.
Okay.
So, we talk about Widows Calabrese's
Cost of accidents.
Quasi-market solution. You said that this is a notion, a theory in which the notion of causation is probabilistic notion, because this theory is interested in the events which often cause a harm and not necessarily cause harm.
It's worse than that. The notion is you place liability on the person who can most cheaply avoid the accident, and that may not be someone who has anything to do with it in terms of causation. That's the theory. It's a very radical theory.
Okay. But if I well, okay, then there is two interpretations of this. One is in your answer, then the notion of causation doesn't play any role in this theory. But if I well understand in your former presentation, the the notion of causation plays a role in this theory, but it's a probabilistic role.
Well, actually, causation plays a role only as empirically likely that the person who causes a harm is among those who can most cheaply avoid it. That's all.
Okay.
Doctrines of American tort law, I don't think, actually differ much from doctrines in Europe. I'm a little curious what we should talk about. Now, we have sine qua non, as you do. There's that whole set of problems, which is a complicated nest of problems. And there's proximate causation, where I see you have the same divergent approaches that we do in terms of many people think it's a matter of policy, but some people in some jurisdictions think it's not a matter of policy. Proximate causation is what Sir Francis Bacon said it was in the 17th century. It's a true causal doctrine. It has to do with causation, not with some policy construct. So you have a lot of the same divisions. I guess maybe a useful thing to do is this. At the end of chapter 4 of the book, I present an outline, which you can sometimes present in terms of a flow chart with various nodes. So suppose you're looking at the law of causation, Anglo-American law of torts and crimes. There are what I call one-step or unified theories, theories that do not distinguish cause and fact from proximate causation. And I actually give some examples of that in the book. Famous article by Jedediah Smith, the Harvard Law Review of 1915, from which the first restatement of torts took some of its language, where he said causation is a primitive. The best thing to tell juries in tort cases is not some test about causation. They know it already. It's like telling them something they already know. You're only going to make it worse. Just ask them whether there's enough of it. So, the famous substantial factor test, in Smith's terms, a primitivist test, doesn't ask for two things, it just asks for one. Was the plaintiff, was the defendant, enough of a cause, not a de minimis cause, to be fairly held accountable for the activity? He called it a substantial factor, but he wasn't a new factor, didn't say anything, just meant cause. So the substantial factor test is what philosophers would call a primitivist test. A cause is a cause is a cause. Doesn't say much, but at least it's true. It's primitive because it doesn't define causation. It simply says, you know it when you see it, and if there's enough of it to hold someone liable, then hold them liable in torts. That does not divide between cause and fact and proximate causation, that kind of primitivist test. There were physicalists. Tests like this at Harvard. Wrote a couple of articles in the Harvard Law Review, 1895, 1920. And at Hart, Richard Epstein at the University of Chicago is very much the same today. Causation is a matter of physical force. And to take Epstein's interpretation of Beale, he means physical force. It isn't this metaphorical stuff that other people like Fletcher talk about. So if you have an auto accident, you determine causal contribution by the kinetic energy of each of the automobiles colliding. So it's 1/2 mass times velocity squared will measure the causal contribution of each to the collision. That also, in both Beale's hands and Epstein's, is a one-step causal theory. There is no difference between cause and fact and proximate cause. It's just one question. Was the physical force of the defendant a big enough part of the overall force required for the harm to occur? So we have primitivists like Jedediah Smith, physicalists like Beale and Epstein. Interestingly enough, although he never sees himself in these terms, Richard Wright at Chicago Kent actually has a theory that is a one-step theory. Because what Wright is someone who says, you never ask, was the defendant's act a necessary condition of the harm? You rather ask a much more fine-grained question. Was the aspect of the defendant's act that made it negligent a cause of the harm? Now, he has a semi-counterfactual notion in mind. What makes it one step is that Richard Wright's kind of theory, like Robert Keaton before it, gives you a very fine-grained counterfactual theory of who's liable. So take the famous case that Keaton used in his book, Causation and the Law of Torts. It comes from the Larimore case in Oklahoma in 1939. Defendant unreasonably stores unlabeled rat poison in the kitchen of a restaurant. Now you think to yourself, unlabeled rat poison in the kitchen, it's with the food, someone's going to eat it and get poisoned, right? But what happens is it has low-grade phosphorus in the rat poison, and storage of the food is near the stove, and the heat explodes the rat poison and it damages the plaintiff waitress. Most of the people who deal with that case deal with it in terms of proximate causation. They ask, is the harm that happened an instance of the type of risk that made it negligent to place the rat poison where it is? And the answer is supposed to be no. Wright gets the same result, but not under proximate causation, but rather under causation itself. He says, is the aspect of the act, well, what's the aspect of the act? The aspect of the act that made it negligent was, he thinks, the unlabeled nature of the rat poison. That's what made it negligent. Was the aspect of the act a necessary condition for the harm? And the answer is no. The damn poison would have exploded whether it was labeled or unlabeled. So the aspect of the act that made it negligent was not a cause of the harm. Wright gets out of that test the kind of discriminating power that Cardozo and others got out of their harm within the risk test, which is why I say he's up with these folks. He actually has a kind of one-step sort of causal test. Tort law in the Anglo-American system is traditionally thought of as a two-step process. You ask first a cause and fact question, and then in Bacon's old terms, you ask about the proximate causation question. Was the in-fact cause proximate enough to the harm for liability to be appropriate? Cause and fact standardly interpreted as a straight counterfactual question, but for the defendant's act would the harm have occurred? Proximate causation interpreted in various ways. I divide them up between policy-based tests and causal tests. Namely, some people think proximate, or sometimes called legal cause, is really just a scope of liability limitation based on certain policies. It's a misnomer from Bacon to the present day to call it proximate causation, because on this argument it has nothing to do with causation. Causation is exhausted when you do cause and fact on this view. As a matter of policy, you don't want to impose extensive liability, so as an honorific term you say it's a non-proximate cause, but it has nothing to do with causation. As opposed to people like Hart and Honoré who say, no, proximate causation is a true causal doctrine. The law calls it proximate causation because it is causation in the metaphysical sense of causation. This isn't enough for causation in the metaphysical sense. You also need what Bacon thought. You need, namely, certain proximate relations. Take the policy guys first. If you look at the legal realist literature in America in the 1920s, people like Leon Green and Harry Edgerton and the like, their view was proximate causation limits liability based on a whole range of policies. As Edgerton said in his famous articles in the 1924 University of Pennsylvania Law Review, you take all of the policies that justify tort liability and decide in an individual case by case, whether liability is appropriate based on those policies, and if it's appropriate, call the causation proximate. If it's not appropriate, call it not proximate. These are just honorific labels for a case-by-case policy maximization. Very good. As opposed to others who said, no, what you should do is maximize all the policies, but you do it by rules rather than case by case, gives people better notice. So you make up rules like the old New York first house rule, which in American tort law goes like this. When the railroads were first getting all those land grants, They would go through cities, and if they didn't have adequate spark arresters on their locomotives, the coal-fired steam locomotives, they caused fires. The New York First House Rule was a rule of proximate causation. What it said was, the railroad is liable for the house that is directly ignited by the sparks. But a house that is one house off the tracks and is ignited by the first house burning cannot sue the railroad. It is per se not proximate if you are the second, third, fourth, or fifth house. Only the first houses can sue. All other houses are not proximately caused damage. Of course, that's a wildly ad hoc stipulation. Because if you're running a locomotive and you know you burn one house and it's right next to another house, it's perfectly foreseeable. Burning the one will burn the other. But on grounds of not impoverishing the railroads, on grounds of subsidizing them to encourage railroad growth, you have the First House Rule of New York. Now that has nothing to do with causation, that's for sure. That is simply a policy-based limitation of liability. Whether it's a good policy or not, another question. Criminal law used to have the year and the day rule. If death occurred within a year of the day and a day of the act of the defendant causing it, then it was proximately caused, but if it was a year and 2 days, it was not. The policy behind the rule was simply the inadequacy of medical knowledge. It was just thought non-justiciable whether you could actually trace causation beyond a year given the limited medical knowledge. So as a per se rule of criminal law, you simply said if it's more than a year, it's not proximate, less than a year, it is. Like the First House Rule, except it's with time rather than space. There was a rule for a long time in the 19th century called the last wrongdoer rule. So when you have those torts that are surprisingly common of successive wrongdoers, each causally contributing in a sense that they're each necessary to an indivisible injury, the last wrongdoer rule said just as a matter of policy, you could only hold the last wrongdoer in torts for the liability, for the damage. All other wrongdoers get a pass. Not because they didn't cause the harm, but because they weren't last under the last wrongdoer rule. That's a policy-based view of proximate causation. There's another policy-based view which says there's really only one policy that should guide here. That's what I call the policy of culpability. Proximate causation is a misnomer, again, because what we're really judging with doctrines of proximate causation is how culpable the defendant was. There's two versions, often confused, but they're actually quite distinct. There's the foreseeability version, where you ask a seemingly simple question. Was the harm that happened foreseeable to the defendant at the time she acted? There's then the more complicated question, which is sort of the standard educated view of torts lawyers in America in the 1920s, called harm within the risk, which asks a slightly more complicated question. You don't ask whether the harm was foreseeable. You ask this question. Was the harm that happened an instance of the type of harm, the risk of which made you negligent to start with? So that in the case where you placed the rat poison unlabeled in the kitchen, if the type of harm, the risk of which made you negligent, was ingestion of poisonous rat poison, the harm that happened, burning of the waitress, is not an instance of the type of harm, the risk that made you negligent, in which event no liability under this harm within the risk notion. In chapter 7 of the book, I go through the history of the harm within the risk. It's almost like a history of American tort law. All the big guys are in there, so if you like the history, you might want to look at that. It's an interesting test in terms of its doctrinal acceptance. Cardozo's majority opinion in Palsgraf, 1927 New York Court of Appeals, famous case in America, was an attempt to write into law his good friend Boland's harm within the risk test. He only got half of it. First restatement of torts only gave him half of it. Second restatement only gave him half. Third restatement gave him the whole thing. But the actual doctrinal home in America of harm within the risk is surprisingly in criminal law in the Model Penal Code of the American Law Institute in section 2.03. So there's this test and this test, both doctrinally. quite well accepted. How about these tests, the causal tests? Well, there's Bacon's kind of test, where you simply look at space-time or number of events, proximity. As Cardozo says in one of his famous opinions, people think space and time doesn't matter, but common sense says it does, just by itself. Simple remoteness tests is what I call those. And then there's the famous direct cause test. Said by Richard Epstein to be dominant in American tort law. I actually doubt it if you count jurisdictions. It is dominant in American criminal law. It is the proximate cause test in American criminal law. It is one of the three dominant proximate cause tests in American tort law. Direct cause. Ponencia's case from England, 1923, is usually used to illustrate it. That was the case where the negligence of the defendant's employee, a longshoreman, was in dropping a wooden plank into the hold of a rather large and expensive ship. Unbeknownst to the employee, there was gas vapor in the hold. The spark caused by the plank, which although wooden must have hit something to spark it, ignited the gas vapor. The whole ship was blown up, and it was like £1.5 million English pounds in 1923, which was serious money. Held liable because no matter how unforeseeable the harm, no matter how much it was not an instance of the type of harm, the risk of which made it negligent to drop it under those tests, it nonetheless was directly caused. Nothing intervened between the defendant's act of dropping and the explosion of the ship that broke the causal chain, and therefore it was directly caused. Many people, my torts teacher when I was in my nappies running around through tort law, my torts teacher used to say, well, what does direct cause mean? I mean, how direct does direct have to be? That just ignores something that should not be ignored. This very fine book by Hart and Honore called Causation in the Law, it's 700 pages long, and it tells you what direct cause is in American and English tort law in detail that's more than any sane person could want. They went to the Harvard Law Library in 1956 before there were computers, and they read American causation cases, hundreds and hundreds of them, and this is the book they got. Someone ought to listen to them because they actually read the cases. You are looking at the only other human being alive who has read with them all of the wild animal cases on proximate causation. Nobody else is in their right mind would do such a thing. In any event, they have a detailed book that I don't just describe it, I actually reorganize it for them in chapter 11 of this book, but it's a thesis worth looking at because it's doctrinally coherent and it fits the decided cases very nicely. So it says, in essence, a direct cause is any cause in fact where there's no intervening cause. Now that tells you immediately you're not doing what the ancient English lawyers used to do when they distinguished direct from indirect causation for purposes of distinguishing the writs of trespass and trespass on the case. Those English lawyers had a much different notion in mind. That's not this notion. This notion will contemplate proximate causal chains and liability over quite extensive lengths of causal chains, so long as nothing called an intervening cause intervenes. All the work is thus done on defining what is intervening causation. If you take the book and resystematize it, it comes out like this. An intervening cause is something that is, number one, causally significant. That is, it has to be a cause on some theory of causation. They have a theory of causation in the book. It's the Ness theory, necessary element of sufficient set. So it has to be a Ness condition, but there's nothing peculiar. Whatever your theory of causation is, an intervening cause has to be a cause. Secondly, it has to be intervening. It has to meet what's called the temporal criterion. It has to occur after the defendant's act and before the harm, so that it literally intervenes as a matter of temporal. Now notice that gets rid of all the pre-existing abnormality cases, because it says no matter how abnormal it was that there was gas vapor in the hold of that ship in Polimas, no matter how extraordinary it is that the person you hit turns out to be a bleeder or has the proverbial thin skull, you take your victim as you find him, as the old common law maxim. What it's encapsulating is this second doctrine of intervening causation. Pre-existing abnormalities do not intervene, they pre-exist the defendant's action. They cannot be intervening causes. in which event liability exists no matter how unforeseeable the harm because of the pre-existing susceptibility of the plaintiff to injury. So the second notion, a temporal intervention requirement. An intervening cause has to be a cause, number one. It has to temporally intervene, number two. Number three, for it to intervene, it has to be, as Hart and Honore say explicitly, an event and not a state. A state exists over a length of time. An event occurs at a short interval of time. An intervening cause has to be an event. It's not a state. It's also not an omission, if you read the cases. Omissions in states under Anglo-American tort law do not constitute intervening causes. Events do, but events alone do. So it's a cause. It's intervening temporally between the Defendant's Act and the harm. And it's an event, not an omission, and not a state. It also, fourthly, has to be what Hart and Honore called causally independent. The English cases call it has to be an extraneous cause. What they mean is this. It can't itself be the means by which the Defendant's Act causes the harm. It can't be in the chain of causes. Hart and Honore give this example. Defendant hits the plaintiff, knocks him to the ground. A rotten tree falls over and kills the plaintiff. Normally, that would be called a coincidence case, and the tree would be an intervening cause. But suppose, they say, it happens this way. Defendant hits the plaintiff. Plaintiff falls back against the rotten tree, which was just about to fall, but it wouldn't have fallen unless the plaintiff's body had hit it. Then the tree falls on the plaintiff and kills him. Now the tree falling is not causally independent, they say, under the cases, and therefore is not an intervening cause. It's wildly unlikely, extraordinarily unlikely, unforeseeable, but nonetheless, there's liability under the direct cause test because the intervening event is not causally independent. Now, in the book, I go with them because I found it interesting into the human intervener cases and the animal intervener cases, because the independence criterion becomes quite tricky. I won't bore you with the details. Here's just a couple of animal cases. You'll get the flavor. So suppose what happens is the defendant's negligence or intentional tort injures a dog. The dog runs into the plaintiff's house, who may or may not own the animal, jumps on the plaintiff and injures him. Is the jumping of the dog an intervening cause? No, as the court said, it's not causally independent, because it's simply a product of your negligent act in hurting the dog. He was running for help. Contrast that with this case out of Texas, city of Waco. Defendant's negligence is letting the dog out. The dog is now running around. He sees some sheep and he chases the sheep across the road, and plaintiff driving avoids the sheep and gets injured. Is the dog's chasing the sheep an intervening cause held by the Texas courts? Yes. Because the dog brought his own motivation to the sheep chasing. It was not supplied by what the defendant wrongfully did. Sure, the defendant shouldn't have let him out, but it wasn't that he let him out knowing that or to in any way motivate the dog to chase the sheep, in which event it's eligible as an intervening cause. So the independence criterion for animals and people becomes a motivational independence criterion. Did the Defendant's Act supply the motive for the intervener? If it did, it's not independent. If it didn't, it isn't. The independence cases are wonderful. My favorite is from Pennsylvania, the Hogsett case. And this is where J.L. Austin's admonition, you can't make this stuff up. You couldn't think of these cases. You may have read this case, Hogsett v. Bunting. Defendant's negligence is in operating his locomotive too fast. He hits the plaintiff who's on the track, but lo and behold, miraculously, the plaintiff's not injured, not at all. But what happens is the collision knocks the defendant's engineer unconscious, who throws then his body while unconscious backwards onto the lever that controlled the engine. And the engine then runs backwards down the track, but someone has turned the switch, and so it goes around a circular track, and now it hits the plaintiff from the other direction as it comes around the track, and this time it injures the plaintiff. Despite the extraordinary concatenation of events under the direct cause test, the Pennsylvania Supreme Court said, but the backing of the engine, all those intervening events were not causally independent of the Defendant's Act that was negligent to start with, so no matter how extraordinary and unforeseeable liability on the railroad's part under the direct cause test, because the intervening events are not independent. So we've got a Intervening cause being a causally significant event, not state or omission, that intervenes temporally and is independent causally of the defendant's act, and two more. And if you read the restatement of torts, it has to be unforeseeable. Hart and Honore's book does a wonderful job of showing why the restatement of torts is wrong about the law that it's restating. Tort law doesn't require that in many cases. Some cases it does. But that's just a matter of reading the cases and counting them up. So let me pass it by. The last thing they say is what every writer preceding them also said. They're not original about this. Intervening causes are only one of two kinds of things. They're either free, informed, voluntary acts of intervening human agents, or they're abnormal natural events amounting either to a vis major, like a big storm, or a coincidence. So they're either intervening human agents or abnormal human events. Those are the only things that can be intervening causes. Put all that together, you do not have a vague doctrine. You have a razor-sharp doctrine with lots of pieces that seems to have appealed to several hundred years of common law decisions that they have read and restated. I don't happen to agree with this test, but I do think you have to take it seriously if you're going to actually argue with it. And the way many tort scholars deal with it doesn't, I think, take it seriously, despite this monumental effort by them to make it clear. Okay, that's roughly the group of tests in American law. We could talk about all of the problems and the doctrinal wiggles you have to do to get around them to make the sine qua non test work. I'm happy to talk about the problems for direct cause. Chapter 12 of my book tries to demolish the Hart and Honore project. And of course, the other big tests we also could raise some questions about. What I do in the book is devote part 3 of the book to the harm within the risk test in 4 chapters, and I devote part 4 of the book to the direct cause test in 3 chapters. I don't do foreseeability because I had a long chapter in a preceding book on foreseeability, but I also try to demolish that test as well. For all of the tests, I ask 3 questions. Are they conceptually coherent? Are they normatively plausible? And do they actually fit the doctrines of the decided cases? 3 sorts of questions. But I should stop here, and maybe we can talk about them a little bit. Whatever you'd like to talk about, we can talk about those doctrines.
What do you think about this kind of cases, the thin screw cases? It is amazing. The restatement third, Michael Green and Company, counted the American cases, and what they found surprised me. It's unanimous. In the 50 American jurisdictions, they still follow the common law rule. You take your victim as your plaintiff. Mm-hmm. I see in European law they've got the same doctrine. What is so intuitive about that? It is interesting. Here's what I think you're trying to do with your proximate cause doctrines in tort. If you think the point of tort law is like you and I think, it's corrective justice, then you need to separate the harms you cause in a robust sense, the ones that go on your ledger that you have to correct, from the harms for which you were perhaps a necessary condition, but that nonetheless are a matter of luck in the sense I was talking about yesterday. It's absolutely freakish, perhaps, that my culpable act caused you harm in that way, in which event it shouldn't go on my ledger, I think, is the 300-year-old common law intuition. Proximate causation looks to me like it's trying to separate results that, although they're counterfactually dependent on the defendant's act in all cases, nonetheless are due to the skill or the intent of the defendant on the one hand, that's where you should be liable, or the freakishness of nature on the other, where you shouldn't be liable. So that if a big storm comes up and takes some negligent thing I've done and turns it into some instrument of harm, well, the big storm should be liable, but not me, and you can't sue the storm, so I guess you're out of luck, is the intuition, I think, behind proximate causation. Now, where do we put freakish plaintiffs? plaintiffs with freakish susceptibilities to injury. I mean, I'm tempted to put them on the freakish side of the line, but the law clearly has an intuition that I kind of want to respect. So I don't know, what do you think?
Well, this criminal law rule, you change your victim as you is, for me, is quite hard. Quite hard because you can find victims with freakish susceptibilities or illness or something like that. It's only to that victim that you mentioned that are, but everybody wouldn't be. In Spanish criminal law, there is no clear rule.
Yeah.
In cases with
You could say for people who are freakishly susceptible to injury, if that's the only way they could be injured, then it's not really negligent vis-a-vis them, because who could have thought that you were risking that kind of injury? The problem is that isn't the cases. The cases are cases in which you're negligent because you actually do risk injury, but you get injury of much greater kind or extent because of the susceptibility of the plaintiff. So, what do I think? I guess I actually think the law is probably right on those cases. It's there's nothing extraneous contributing. There's no sort of freakishness of nature or someone else contributing. All that is freakish is the fact that the person in front of you is really susceptible to injury. But in terms of the causal relation, you injured them. If it was negligent or intentional on your part, then I guess the court laws that we have is probably what I would. But I'm, as you can see, hesitant about it.
you would say it is the cause.
Yeah, I think so. I do think so.
I would say that it's a pity that I have to go, and you are not going to talk much longer anyway, but the causation, in fact, it would be interesting, probably you can talk about that, but I would say that all these rules about proximate causes, to put it one way, are anti-freakish rules, so to say, you know?
Yeah.
The situations that are abnormal, something like that, you know? But in this case of the fiscal rules, or you take the victim as you find him or you find her, you know, I would say that this is an exception to foreseeability, you know, and it's a sort of trade-off, at least in the area of tort law, a trade-off between the right that individuals who have a special ailments or a particular situations, you know, the right they have to move along, you know, free, knowing that if they have a problem, someone is going to take care. And also the right that people have, that if they know they behave properly, they are not going to be made responsible for things they should not. So in this case, you are liable for someone who has a special situation, but because previously you have done something wrong. You know, I mean, if you have done something properly, you're not going to be liable for the freakishness results. So it's, so to say, it's an exception of one of these anti-freaky rules. Right?
Well, I think it's certainly an exception to foreseeability. I mean, it's very hard to think that the freakish susceptibility to injury cases was in any sense foreseeable to the defendant at the time he acted. It is an odd sort of, it's one of the ways in which the foreseeability just doesn't fit the decided cases. It's supposed to be the case you're liable if and only if the harm was foreseeable. It wasn't foreseeable, but you're liable anyway. That's a direct contradiction of foreseeability as a univocal test of liability. Somehow it matters to me as much as it matters to the common law lawyers. If the freakishness is pre-existing, then under the direct cause test, you cause, whereas if it intervenes, arguably you don't cause. That's an intuition that I find a little hard to make sense of, but I certainly seem to share it in terms of the causal relation being intact. You know, you caused it because the previous stuff, as Hart and Honore says, well, that was all the stage setting on which your action intervened when it pre-exists. Whereas if it comes after your action, well, then it's one of the things that competes with you as the cause of the harm. I guess I share that intuition causally.
With problems of previous abnormalities, I have the thing that arises from an argument that you developed in your book about harm within the risk, culpability question.
Yep.
You pose two counter-arguments against the risk theory, which are the descriptive problem and the all-inclusiveness.
Yes.
You cannot select
Yep.
which risk is relevant for doing the test.
Right.
And you make an argument very compelling that they use, for example, one of the rejoinder is, well, you can select the risk that it is obvious from the plaintiff's view. So the way that you can describe or select that the risk that it is relevant for the test is the most obvious risk that you take when you make the act. Yeah. Your argument, your counter-argument is very interesting. You say, well, this risk is a moral notice that you are engaging a risky activity. So you cannot calculate, you cannot make the extensive learn and hand version of the calculating that if you're making or not when you're acting on a reasonable risk. But if you have an obvious risk, you have at least, which is very relevant for a culpability test, you have the notice that you're making something that could be result in harm. So you point out that if you cause a non-obvious risk, well, you at least have a moral notice that you were. So you have to be responsible, culpable for non-obvious risk. But taking that argument for this case, you can see, well, you have moral notice that you are engaging in risky activities, but you have to have a proxy also for the extensive of damage that you are engaging. So, for example, if I hit somebody who has a very thin skull, I think that my proxy is he would, have a face, face concussion or hurt, but I don't think that I will kill him with a punch. So I did not, I have the moral notice that I was engaging in a risky activity, but I didn't have a proxy of the moral notice that I could kill him with a simple punch so I think that you can make that argument not in causation, but in your culpability complementary judgment.
Yep. Yeah. Again, thank you, as yesterday, for the careful reading. That's chapters 8 and 9. It's actually 3 arguments, not just 2 that you've accurately restated. The 2 arguments from chapter 8 are conceptual arguments. They're arguments that the harm within the risk test is conceptually incoherent. And as you say, it's the typing of the risk problem and also the all-inclusiveness of the risk. Now, the typing of the risk problem is the kind of problem that beset Fletcher's theory of torts, for example. When are risks reciprocal? Well, when are they of the same type? If I throw a blue ball at you and you throw a red ball at me, is that the same type of risk, or is one of them a red ball versus a blue ball risk? If you have an ocelot and I have a shepherd, is that a wild animal risk, or are those different risks? If you have an ocelot, I have a shepherd, and I have a Mercedes and you have a Volkswagen, are those of the same kind of risk, or are those different risks? There's not an obvious typing of risks. That's the typing of risk problem. And of course, you can get harms within a risk more often the bigger you make the risk. So unless you have principles for risk sizing, the test is radically indeterminate. To which you respond, but people might have, a plain man might have an intuition about the size of the risk and the salience of the risk, this risk rather than others, and the sizing of the risk, it might have a sort of natural typing. Sort of 2 things I raise in the chapter about that. It's possible, but as a matter of sociology of human belief, do human beings size risks in any natural way that we could capture with a good sociology? I'm not saying they don't, but I sure would like to see the data that they do. If you look at people who deal with similarity in sociology and judgments of similarity, it's not obvious people have any natural categorizations of the types of properties that make one thing similar to another. It looks highly contextual. And the same may well be true of risks. But suppose people do have a salient typing of risks. The other thing raised in Chapter 9 is, Chapter 8, why would that be normatively relevant? Why, if most people happen to type risks at a certain level of description, should that give the law, in its harm within the risk test, the type of thing that you ask, that's the type of risk, the instance of which should make you liable? Seems to me that people may have that sociology wouldn't answer the question about whether the law should use it. So that's the typing of risk problem. The all-inclusiveness of risk problem is this one. The restatement of torts third gets right what I think is implicit in learned hand to start with for what negligence is. It is not a risk. It is a summation of all risks that an activity poses versus the precautions necessary to lessen all of those risks. It's holistic, it's all-inclusive. And the moment you say that about negligence, then in what sense can you pick out a risk and ask whether a harm was an instance of it? Every harm that is in fact caused by an activity obviously was risked to some degree by that activity. Couldn't have been caused if it wasn't risked. If negligence is the summation of the total basket of risks, as many judges have said, and so does the restatement third, then how can you do what the restatement third does, which is ask whether the harm that happens is an instance of the risk that made you negligent, because every harm that happened posed some risk, and that risk went into the basket of risks that made you negligent. I find that a completely incoherent test that makes you liable for all harms that happen. So it can't mean that. It has to pick out some salient risk that occurs perhaps to the plain man. So the unlabeled rat poison, you think, well, the risk is you might eat it. Well, of course, there was some risk that it would explode, because it did explode. Must have been some risk it would explode as well. It must have been one of the risks that went into the basket of risks, making it negligent to place the rat poison where you placed it. So that's the all-inclusiveness problem. The third problem you raise is really a normative problem, not a conceptual one, which is Judge Friendly's opinion in Kinsman Transit when he says, well, but if you're negligent because you do something that risks some smaller harm, but it's enough of a risk and a probability of a risk to make you negligent to do what you're doing, and then some other risk causes a much bigger harm, but the risk was sufficiently minimal that it wasn't enough to grab your attention. Why should the person who suffered that risk suffer it uncompensated? You were doing something you shouldn't do. You, in fact, caused the harm. You should bear the loss, not the person who suffered it. That's a normative argument. This says even if harm within the risk has the conceptual resources you want to attribute to it in terms of there being a natural typing and a natural salience of certain risks over others, and the law should use those, nonetheless, I thought Friendly was basically right when he said, yeah, but you're a wrongdoer. You did what you shouldn't have done. Lucky for you, the risk that made you wrong didn't materialize, but another risk did. You should pay for the harm caused, not the person who was completely innocent in the production of that harm. That's the normative argument that I think is Chapter 9 that you accurately capitulate. And having gone out that length, I've forgotten. Why didn't you like those arguments?
I think that such argument can be used for the abnormal pre-existing condition of the victim. Because the question was, you point out that the obvious risk give a moral notice of your engaging in a risky activity, but can you use the same argument for the proxy argument for the extent of that?
Yeah, you could. You could use the normative argument. The conceptual arguments would remain unanswered. You still don't have a natural typing of risk or a picking out of a salient risk. But the normative argument, you're right. You could say, look, the thin-skulled man cases are all cases in which there's some risk of some damage sufficient to make you negligent with respect to doing what you're doing. You shouldn't do it. And then that he has a thin skull gives rise to much greater damage, but you should pay for that because you're doing something you shouldn't do, and it in fact causes the harm. And then you rightly see Something that I think criminal law does, but tort law would not. Namely, in criminal law, you would then make a culpability, not a causal judgment, about whether when you kill someone, when you thought reasonably all you were going to do is hit them, but you kill them because they have a thin skull. Criminal law, actually, I think, will not hold you liable. You caused the harm, but you didn't have the culpability with respect to the harm caused to make you an intentional killer. You may be guilty of manslaughter, but you're not going to be guilty of murder.
Yeah, and you have that mens rea restrictions that you don't apply in tort law. But
Well, you have it in tort law only to this extent. You'll call it negligent torts rather than intentional torts.
But in the public case, in the poison blood case, when it's a bottle of glass that has the cap damaged, and somebody drinks and gets hurt, and then the blood for his special condition gets
Right.
poisoned and dead.
Yeah.
I think that is a very extraneous, I don't know, you don't have a moral notice for a broken top of a glass to causally, to, I don't know, negligently being responsible for the death of somebody. Can you use that argument for the system?
Well, but yeah, wouldn't Friendly make the same argument, which is, look, you shouldn't produce, if there was a cost-effective way not to have chipped glass on the bottles that you're selling, then you shouldn't have been selling that chipped bottled glass. That it caused a harm that is unforeseeable or outside the risk that made it negligent to have chipped glass bottles is neither here nor there. You're doing what you shouldn't do, and you caused the harm, you should pay for it. I share Friendly's intuition, but it's not that it fits the harm within the risk test, it's intended as a refutation of it. Because harm within the risk would say, well, there's a salient risk and the harm that happens is not an instance of it, so you're not liable, to which the answer is you should be. The test normatively then becomes undesirable if you agree with that argument. Let's try a related question. Take foreseeability, which seems to be a favorite of people because it's so simple. What I argue in a previous book is not that foreseeability is a vague test. It surely is a vague test, but you don't have to be in law very long to have a pretty good tolerance for vagueness. Lots of things are vague and perfectly serviceable anyway. The problem with foreseeability is the danger that it's not vague, it's completely vacuous. That what goes on when people say foreseeability is actually a mental process having nothing to do with foreseeability. It's other causal intuitions under which foreseeability then becomes the label but not the reason for the conclusion. Now that's an old argument. It started with Clarence Morris, who was my predecessor teaching torts at the University of Pennsylvania back in the 50s. Morris put it in terms of description of the harm. We'll change that in a minute, but here was his way of putting it in the 50s, 1951. He said, if you look at the cases using foreseeability as a criterion of proximate causation, what they don't seem to see is that it matters how you describe the harm as to whether it is or is not foreseeable. And he gave some examples of cases where if you describe the harm in detail, just take an ordinary brick falling on a head case. If you describe the harm in detail of a crease in the skull of that much depth and that much length in a certain location, well, it's pretty unforeseeable that a harm like that would happen. If you describe it very generally as an injury to a person, for example, it makes the harm foreseeable. So the foreseeability varies strictly with the level of detail in terms of which you describe the harms foreseen. To which he then said, so you need a matrix for how you describe harms, because if it's up to you, you can have foreseeability or unforeseeability completely determined by the level of detail with which you describe the harms. It's not actually a description problem, it's actually a typing problem. Probability theorists, when they think about the foreseeability of harms, that is the giving of a probability about harms, you're not talking about particulars, you're talking about types. So that there's for logicians, there's a hidden existential quantifier. When you make a predictive judgment, you're not predicting the fire. There hasn't been a fire yet. You can't refer to the fire as a particular. What you're predicting when you predict fire is that there will be some instance of the event type fire that will occur. So you're actually typing the event, and it's a question of whether some instance of the type will occur when you're doing foreseeability or probability judgments. The question then is, what's the type? It's like the size of the risk question for the harm within the risk test. What's the type under which you ask, was an instance of that type foreseeable? You need some rules about typing to give foreseeability any content. Now, this is not the vagueness objection. With vagueness, we know that you have clear instances and clear non-instances and penumbras in between. That's not this problem. It's all penumbra. Unless you have a principle of typing of the harms that are supposed to be foreseeable, you can make any harm unforeseeable, any harm foreseeable as an instance of certainly broad or narrow types. That's the problem with foreseeability. And we get back to the same sort of discussion we had with the typing of risks. Do people naturally type harms? Hart and Honore see the problem, actually think when they're dealing with abnormality, they think there is a sociology of typing. Take any event, any harm that you can think of. Is there a social science experiment you could run that would actually show you that people have a natural typing of that harm? As suppose one of us slips on the sidewalk outside. If we do a quick survey where we all have seen the accident, would we have a coalescence, nice bell-shaped curve, on the breadth of the type of injury of which that was an instance? It was a right arm injury, for example. It was not just a right arm injury, it was a right wrist sprain. It was a debilitating injury, it was an irritating injury, it was a way of making the world worse. I don't think there's a natural typing that solves this foreseeability question. And then also, if there is, it's not clear why the law should use it, is the problem. People think foreseeability says something. Here's what I say in the book. People think similarity judgments say something. But look, every particular is similar in some respect to every other particular in the world. It is dissimilar to every other particular in the world in some respect. To say X is similar to Y presupposes you have a set of properties by virtue of which it's similar. Unless foreseeability in the context of utterance can give you the typing, it says literally nothing. Which means something else is going on when you're using foreseeability judgments. I notice you substituted freakishness. That's what I would substitute. It's basically what Hart and Honore substitute. They call it abnormal conjunctions of natural events. How freakish is it? It's not really foreseeability at all. It isn't what it pretends to be. It's an empty test with no content. Fortunately, we're all smart enough intuitively to substitute something else when we use it. That, in a nutshell, is the argument of the previous book that I incorporated into this one. Don't know if anyone wants to argue with that or not. Or elaborate. You could agree with it, too. Let me ask you then, I don't know how much time you want to go. You want to go a little bit more? Let me ask you this question. Let me ask you the question of chapter 12 of the book on the direct cause test. Hart and Honore think this is a causal notion. Can you make sense of the direct cause test where you use intervening causes of one of two kinds, fully and free and form voluntary human actions or abnormal natural events as interveners? Can you make sense of that as a causal test? That is a test that has to do not with policy, but actually measuring when the natural relation of causation does and does not exist between two events. That's the trick to making some metaphysical sense of this legal doctrine called direct causation, intervening cause. Let me give you just a little bit of filling. Take the intervening human agent cases, of which there are thousands. As Hart and Honore detail, when I sort of reorganize, there are four sorts of criteria for when an intervening human agent constitutes an intervening cause after they've met all the other criteria that I gave. Namely, it has to be a voluntary act in the sense that it has to be a willed bodily movement, not an involuntary bodily movement. It has to be that. it has to be intentional or at least reckless with respect to the ultimate harm caused. That's a big one. Take this case from Kentucky in 1912. The defendant negligently spilled gasoline through the town, and the whole town burned up. That's because an individual not connected to the defendant dropped his cigar in the gasoline, and the gasoline was ignited and burned down the town. It's Watson versus Kentucky and Indiana Bridge Company is the name of the case. The case went to the jury under the following instruction. If the defendant who dropped the cigar didn't drop the cigar, but intentionally threw the cigar because he was a pyromaniac, then his act of throwing the cigar was intentional with respect to the harm for which the defendant is being sued, the destruction of the town, and it constitutes an intervening cause, and the defendant did not directly and thus not proximately cause the harm, and can't be liable. But if the defendant inadvertently dropped his cigar, even if he negligently dropped the cigar, as long as he wasn't aware of a risk of conflagration, then it's not an intervening cause, and the defendant railroad who spilled the gasoline negligently is liable for the destruction of the town. So the second condition for an intervening human agent is that they be intentional or at least reckless with respect to the harm. Most negligent or other inadvertent interventions don't constitute intervening causes. So we need a voluntary act, we need intentionality or at least reckless belief. Thirdly, he can't be acting under duress, either the duress of human threats or of natural necessity. So in the 9/11 scenario, the September 11th scenario in America, when all those people jumped out of the tower, if we ever caught bin Laden and sued him in torts, could you hold him liable for proximately causing their death? Well, they intentionally jumped, right? They knew they were going to die and they jumped out of the building. Is their jumping an intervening cause? Answer of the case is no, because it fails this third condition. The duress of circumstances was such that the choice was either burn to death or die by jumping. When they jumped, their choice to jump is therefore not the free, informed, voluntary act that breaks causal chains, and therefore bin Laden is liable for their deaths on the direct cause theory. And fourthly, the actor whose voluntary, intentional, free act breaks causal chains has to be a sane, rational, sober actor. No idiots, no insane people, no infants, and no severely drunk people will constitute intervening causes. They need to be in full exercise of their mental capacities to be an intervening cause. So in detail, they chart how the cases draw human agents being an intervening cause. Off the top of your head, what sort of metaphysics could make sense of agents being human causes? They don't do this, but I think it's hinted in other people's literature. If you're what people in philosophy call a libertarian in your metaphysics, if you think that human beings are what Aquinas attributed to God, namely they're prima causes, they are uncaused causes, then the argument is, when an intervening human agent has these characteristics, the voluntary act, it's intentional by a rational agent, not under the duress of circumstances or human threats, it's free. That's a free act that starts a new causal chain. And therefore, if one of those things intervenes between the defendant's act and the harm, it's a chain breaker, it's a fresh causal start. And the defendant is not liable for the harm that the intervener, by free choice, has started in his new causal chain. If you have the metaphysics of free will, in other words, you can make sense of intervening causation. The problem is, metaphysically, that's just a big hog choker. It's really hard to think human beings are free in that sense, but of course there are people who think that.
It seems that the meaning is to transfer completely the responsibility to the intervening human being.
It is, but the argument is, it's not the last wrongdoer rule. It's not as a matter of policy. This one's supposed to be based on the metaphysics of causation. If human beings really have the capacity to start chains of causation with nothing causing them to do it, then when one of those guys intervenes between your act and the harm, you literally don't cause the harm. That would be the causal insight. I saw a hand down here. Yeah.
The first one, the reactions are precious power. Okay?
Right.
Very interesting. The question is, okay, you have to decide which is the. Sorry, I am not a lawyer. I have no idea. I'm using most part of this question because I'm not a lawyer at all. But the question is, you have to decide. We have two options. How imputing causal responsibility with legal consequences. There is an intervening. One intervening cause, there's a star. The intervening cause is the place where to put causal responsibility with the legal consequences. If it's not, the intervening cause doesn't stop the putative causal responsibility of the original causal chain. That's the responsibility.
That's the rule, and it also doesn't stop the intervener also being liable. They both can be liable as joint tortfeasors.
They both can be.
They both can be liable if the intervener is not an intervening cause. They both can be liable.
But let's assume that the intervener, the intervening cause is a proper intervening cause, precious star, break of the causal chain. What has to be any consequence about the putative causal responsibility of the original cause? For instance, we could imagine that is part of the thing that the original cause that has been intervened still can be a sine qua non condition. Okay? Can still be a sine qua non condition for the result.
Okay.
And imagine, for instance, that it's completely normal that when you start this original causal chain, it's completely normal.
Sure.
An intervening cause could happen.
Yep.
Why does it happen in the intervening cause? Diminish the causal responsibility of the original cause. There is one.
Two things. One, Chapter 12 agrees with you, but that's not going to make an interesting discussion, so let me pretend I'm Hart and Honore and pretend to disagree with you. The argument would be that liability, legal liability, should track your moral blameworthiness in torts and criminal law, first step. Your moral blameworthiness depends on your causal responsibility, second step. And you don't cause what some human intervener intervenes to cause if he's a free, fresh start, third step. Now, I think it's the third step you disagree with. So do I. But the argument of people who believe it is, well, but if human beings are special, they're what Aquinas, as I say, attributes to God. They can cause things without being caused. In which event, if they intervene to cause, well, since they themselves are not caused, they relieve the first person from being causally responsible, thus morally responsible, thus legally liable for the harm. That's the argument. Now, Chapter 12 of my book tries to argue that the first causer actually causes, through the intervening human choice, the harm. So if you don't want to hold him liable, it's got to be on some basis, but it's not on a causal basis. That's what I argue, and I think you agree with it.
I think that he was pointing out the cases that are called given opportunity, where the intervening cause was completely foreseeable, for instance. And that was normal that somebody. I agree with his arguments about the emptiness of the foreseeability aspect. But whatever way you discharge the foreseeability condition is accessible to the problem. The conditions in which we consider that
Sure, sure.
Tort,
Nope.
it's not a free event in the definition of following something.
Yep.
Therefore,
Sure.
I don't see why the formal features of that.
No, I took your point on that, and make it a case where it's not just foreseeable, it's foreseen and it's even intended by the original actor. So take the famous Dr. Death in America, Dr. Kevorkian in the state of Michigan. He's very careful. He's read the Michigan proximate cause cases. He knows that his death machines have to leave one thing for the victim to do after he's done, because then the victim will be an intervening cause with respect to the death, and he cannot be held liable in torts or criminal law for the death. So he constructs machines on proximate cause notions of the direct cause variety, leaving the victim to be the intervening cause. Now, it's not only foreseeable and expected, it's intended by Dr. Kevorkian, right? Nonetheless, the Michigan Supreme Court, following their proximate cause notions of the direct cause variety, consistently said, until the Michigan legislature passes a special statute to get him, you cannot convict him for causing the death of the victims, because intervening between all of his actions in setting up the machine and counseling them and giving them the shots and all of that, intervening between everything he did and their deaths was the choice they made to pull the lever or push the button, whatever he's left for them to do. And that intervening, free, voluntary, informed human choice, intentional with respect to the death, not under duress by a sane and rational, sober adult person, breaks the causal chain, even though it's fully expected. That's what this doctrine says. Now, I do argue in the book the doctrine makes no metaphysical sense, which I think you agree with me, but that's what it says.
This question has not related only with possession. I'm interested in an underlying argument that you make in this discussion. The hard point of view of the libertarian point of view is founded here in the distinction, or the apparently categorical distinction between most causes and reasons. And we are lawyers, we are really educated in that sort of categorical and metaphysical important distinction between things and persons as the two most important particulars for law. And I agree with you that that distinction, I think that is bad metaphysics as a categorical distinction, but as causation, as you argue in your book, is on a scalar, has an scalar nature, as the substantial cause doctrine shows, as Proximus shows. I think that the distinction between causes acting over persons and reasons are a degree, an important degree of distinction. For example, if you take the second order distinction between not choosing what motive do you have, but what kind of person do you want to be. For example, when you reconstruct the steps for causes, for choice of character, motive, intention, I agree with you that normally you can't explain in a causal way of talking all your motives or your intentions. But in the choice of character, you have a long-term kind of choice about what kind of motives and intentions you will have in the future. You can make some kind of, I don't know, I would call it second nature. I know that this argument is not important for your discussion in conversation, but I am interested in your philosophical background about if you can really try to defend an important degree distinction between reasons and causes, while the causes are the natural consequence, humanly speaking, of your choice of character.
So I think you think some kinds of choices might be special. Is that right? The literature I referred to on reasons and causes from the ordinary language philosophers at Oxford and Cambridge in the 60s, 50s, and so forth, were all by people who wanted to defend a version of free will. They wanted to defend human beings and human choice as special. So that it was explainable, they said, yeah, but it's explainable by reasons and not by causes. That's to get rid of, as Meldon said in his book, Free Action. That's to get rid of the idea that actions are just natural events caused like any other. You have to say something about why they seem so easily explainable. He says, well, they are explainable. They're explained by something categorically different, reasons rather than causes. I don't agree with any of that. I don't think choice of character is different or special either. You asked philosophically my general views. I've been head of the research group for the MacArthur Foundation the last 3 years on the neuroscience of human intention and human decision. I am the last person on this earth to think that those are not fully causal processes. We have a phenomenology of choice that may mislead us systematically, but that human choice is caused, I think, is established beyond adventure, beyond any doubt. So I don't think choice of character or choice of anything is outside the causal order. It causes, and it is caused, but it's still choice. And we can locate where within the various areas of the brain it actually occurs. The kind of fMRI studies that we've done, you can trace it down the various motor pathways back up to the precuneus. So I don't know where you want to go with that. You asked for my general philosophy. I am a full-blown mechanical determinist about human choice. I don't know if that answers in a way that's going somewhere you want, but go ahead.
Okay, it's time to finish. Thank you very much for these 2 wonderful sessions.
Well, thank you very much for having me.